Vegas, and welcome to Chris Garcia, the Conservative American. And as always on Wednesdays, we have the illegal mortgage closer expert, Eric Messi, right now with us. Eric, how are you doing today?
Oh, I'm doing pretty good. How are you doing?
I'm wonderful, Eric. I'm wonderful.
Yeah.
What's been going on?
Pretty much the same thing this week.
Yeah.
I'm helping a lot of people that actually have counsel. They have attorneys. And as I can see, there's a lot of things that attorneys cannot do. They can become sanctioned in the court and that kind of thing. And in some states, the difference between judicial and non-judicial, like Nevada's non-judicial, in a judicial state, they actually have to bring it before the court before they can foreclose. But at the end of the day, it's not making much difference anyway because the judges are just simply granting them.
Yes.
In most all cases, even right through the homeowner's attorney and and their all of their counsel. So I'm currently helping a person right now trying to do things over and beyond what the attorneys can't do, like creating subpoenas and things after it's already been ruled upon that they don't have to provide such documents. But the difference between pro se and having a counsel, you could do a lot of these things. The courts can't demand upon a homeowner that's not a licensed attorney to know all of the laws, the various laws and rules of the court. So there's a lot of things that a person can do pro se over and beyond what an actual attorney can do.
Yes.
So I was trying to help him with subpoenas and things of that nature and do that kind of thing that's outside of the norm. The best way to do these cases, it's like playing tennis where you're going to hit the ball to the left, hit it to the right, keep going, and pretty soon they're going to trip on themselves in court. And that's pretty much how I render it and how I help homeowners and things, because you're going to catch them blindsided on what these attorneys that supposedly protect banks and servicers. They're used to the same old cut and paste replies in the court and getting away with it. But if you do things out of the norm, then they have a hard time replying to it.
Yes.
So that's kind of the name of the game, make it really rough. And it's just like playing tennis back and forth and get them to trip on their own selves and start recording a bunch of documents that overlap each other. Sometimes you'll get double assignments, 2 or 3 assignments stating the same thing, which that makes all the assignments cloud each other. It makes them meaningless because you can't have 2 documents purporting the same, road of path, so to speak. So it's going from select portfolio to petty max servicing, and then you got another assignment stating the same thing. It just doesn't work that way. That's basically you're getting them to trip on themselves. One of the important things that I did in my case, and I was amazed, is when I did subpoenas to the purported trustees in the mortgage, most all of the trustees complied with the subpoena and right away replied to it. And they all stated, no, we're not the trustee. Then it brings the question, why are they creating all these assignments on my homes, stating that it's basically the trustee is like Greenhead Investments or anything like that. And Greenhead is owned by Sierra Pacific Mortgage. But they all replied back and said, no, we're not the trustee in that loan at all. Because I would ask them, what is it that you do on a daily basis and things of that nature as a trustee. So they just quickly responded and said, no, we're not the trustee. So that doubly proves that these assignments are bogus and fraudulent recorded on these homes. So do you have any questions regarding this?
Yes, one of the things that I was reading, Eric, is that I was reading about how the banks are required to determine before they foreclose if a homeowner is eligible for a loan modification, and if they're or any other kind of help that will help them catch up on their mortgage payments. And it is illegal for the banks to have a foreclosure going at the same time as they're trying to help the homeowner stay in the home and do a loan modification. It's called dual tracking or something like that. It's illegal.
Yeah, it's called dual tracking. Originally, California is the one who designed that law and created it. And then Nevada generally follows a lot of the laws California does, so then it went to Nevada. Then after that, then it became a federal law. So they can't dual track in any state, no matter where it is.
Yeah.
One of the good modifications that people should thrive for is the HARP modification, because under the HARP program, they're supposed to lower the entire balance down, remove fines, and lower the entire balance down to what a homeowner could afford. So say the homeowner lost his job and then he's being paid a little less now, and that's the kind of thing that a homeowner should go for, and what the bankruptcy courts are actually pushing for, because they get these unable to validate debt claims all through the bankruptcy courts every day. So they're getting tired of hearing this from all the homeowners. So they're actually pushing for people to do a HARP modification right inside of bankruptcy. That way, and that's one of the best ways a homeowner can do it, because now you have a U.S. trustee and a judge as a witness that you qualified for this HARP modification. That way, 8 months down the road, say you go on making your payments, and they go, well, that was only a trial period, so you didn't qualify, so we're foreclosing anyway. Then, your guarantee and your response is this was all verified through bankruptcy federal court. You cannot do this. Because this is where people are being shammed. They'll purport that they qualified for the HARP modification, but at the end of the day, they go on making this 8 months worth of payments and then lose the house anyway. That's not fair.
Yes. Yeah.
So that's one of the things that I try for when I help people, is right through bankruptcy court and get it done that way. If you go into bankruptcy just stating 20, 40 ailments that the servicer or the bank did, then you're not stating you're ready to reaffirm the debt and resolve the debt. Right away, the judge just wants to throw the homeowner under the bus and just throw the case out. But if you're headlighting it that you want to modify via HARP with the government, and you get this modification done through the government, you want to make sure that you're modifying with the beneficiary lender, the owner of the note. A servicer on their own merit can't modify anything. It has to be under the authority of the lender. If you read your deed of trust, your agreement was with a lender, not a servicer.
Right.
So you're stating this is basically how I state these cases, is that I want to modify via HARP modification with the beneficiary lender, the appropriate people, because in layman's terms, the government wouldn't want to put any funding into an illegal loan, into just a solely a servicer loan with no beneficiary lender, because nobody would want to do that. You don't want to put $100,000 or $200,000 into something that's a liar's loan.
Right.
So basically, that's how I word it, like as if the homeowner's trying to protect the government at the same time that they're trying to get a legal modification.
Yes.
So that's what I thrive for, and leaving it pretty much to where, how can a judge just throw that out when a homeowner is stating they want to modify and resolve the debt?
Right.
That's what bankruptcy is for, and you're supposed to be protected under bankruptcy. They call it bankruptcy protection for a reason. And the difference between a Chapter 7 and a 13, a Chapter 13, you have to have a plan. You're agreeing to pay all of your creditors just less than, and this is how much I could afford a month. And then you pay directly to your U.S. trustee. A Chapter 7, you're going for a complete discharge.
Right.
And they don't ever want to discharge a secured creditor, like when a servicer comes in and says, hey, this person has a mortgage,
I don't want to sound.
With bankruptcy, you get that automatic stay. You're getting an automatic TRO with it.
Right.
Of course, these perpetrators and these illegal debt collectors want to file a claim 4001 and get relief of stay. Then the homeowner has to object at that point and then file an adversary proceeding and asking for a proper hard modification right in bankruptcy at that point.
Right.
So that's how I've been helping homeowners on a daily basis. They've just been hammering me left and right from Texas, Florida, just about every state, you name it, because they're all after these homes now. They're trying to hurry up and end this. And of course, the hard modification, it is set to actually go away in September of this year, and people won't have that as an option anymore.
Wow.
So this would be the perfect time, of course, to do it and go for a hard modification before it ends.
Yeah.
Because we do have a new president. So
that's right.
I don't
want to sound ignorant, Eric, but I just want people to know, and I want you to explain this to them. The bank cannot kick you out of your home without getting a court order and filing for eviction, and the bank cannot padlock your door if you're still living in your home. Just express that to people. Let them know, Eric, because a lot of people don't know that.
Yeah. Well, in Nevada, I have not seen that to ever be true. They'll foreclose and then just turn around and kick you out of your house. They may try to offer you cash for keys, try to be nice about it in some cases, but they don't. All they have to do in Nevada, non-judicial state, is just foreclose and kick you out of your house. They don't need a court. In a judicial state, they need the court, and there's some of those proceedings they have to follow. But like I was saying earlier, the judges just grant them anyway, so you don't gain a whole lot in a judicial state anyway, because the judge will just grant the unlawful detainer and kick you out. The foreclosure's the foreclosure. It's done. I've already ruled on it. Kick them out.
Right.
So in Nevada, they'll just go and kick you out. They don't need any court or any approval. They foreclose. They contact the sheriff, show them that they're kicking you out, and that's it. The story, you're out.
Wow.
So I'm not sure where you read this at, that they need a court order to kick you out. I've never seen that to be true.
Now you have the right to occupy your house during the foreclosure, right, Eric?
Yeah, I mean, there's a lot of people still in their homes, and they'll stay in there as long as they could, but then they start moving the court to they could move the court in your bankruptcy if they get relief of stay to get you out of your house. They could do that, but you have to object. But if you're not in bankruptcy, you're not in any court, they don't have to access the court and get a judge's order to kick you out.
Right.
Not in Nevada. They can just automatically do it.
It gets deeper and deeper. And again, I was reading something also about, and this is something people I've never heard of, but explain to the people out there about field service companies or their subcontractors, and they inspect the properties, because I've been reading a lot about how they come to these properties and they're inaccurately deeming these properties to be vacant when actually there are people still in there.
The real name is called preservation companies. That's the name of it. That's what you want to research in Google. Okay, one of the biggest is Safeguard.
Right.
So
they just got sued in the state of Illinois.
When you start noticing a car across the street casing your place, and you're starting to get that sense of somebody's going to enter your house.
Yeah.
The first company I always recommend is you call Safeguard, and you be real nice to them. You just give me your address, and you ask them, is my house in your database? And if they say yes, then you order them to take it out. You have no authorization to come here, period.
They just got sued, Eric. Safeguard. Safeguard. They got sued by the Attorney General in Illinois.
Oh, yeah.
For illegally breaking into occupied homes.
Absolutely. And I've seen cases where Safeguard was using the GPS misguided them, and they went to the wrong person's house and threw everything away. It was a teacher's home.
Oh, my goodness.
And she had all
Oh, wow.
And there's things that you just can't replace. And she was so upset. And Safeguard's response was, oh, that's not our fault. The GPS just misguided us. It's not our fault.
Oh, my God.
You know, so Safeguard's phone number for people to call is 800-852-8306. And that's what you want to call. You want to start there. They're one of the biggest, and they're even involved in taking properties too. You'll notice on their website, they're called Safeguard Properties, but you'll notice on their website that they're actually selling properties as well. And to me, I don't see any right that they have to be doing this. How are they taking properties and flipping them?
Right.
They're not a bank. They're not a lender. You know. So, yeah, I've seen all this. I had a situation with my own sister in Vancouver, Washington. And they started noticing, hey, what's this strange car out front, you know, looking at their house. And all of a sudden, as soon as they left, these guys went into the back barn and stole all their tools out of this back barn. So I called Safeguard, found out that property address is in their system, and I told them what they did. And I said, I'm contacting the police because I know who stole these tools. Well, that night, they went back and brought all the tools back and put them in the barn.
Wow.
And this happened to my own sister. So this is
Wow.
You know what I mean? And
Wow.
I helped her with her foreclosure, and that was through the servicer Caliber, because HSBC was the original lender of the loan. HSBC got to where they couldn't foreclose, especially after they were busted for drug trafficking into Mexico. Under HSBC.
Oh, wow.
And so they said, well, that's easy. We'll just start buying out these servicers and continue foreclosing, just say the loan transferred there. So they actually created Caliber Home Loans. So when Caliber forecloses, HSBC is actually behind it.
Wow.
And that's how they're getting around all this stuff. And then they purport and state that these servicers are only licensed as servicers. They're not a bank. A bank is licensed. A real lender is licensed in Delaware, New York, and they're federally chartered. Okay, a servicer is not just solely a servicer. Bank of America could be a servicer or a lender. They're licensed for both entities, okay?
Sure.
But somebody like Caliber Home Loans, Select Portfolio, PennyMac, they're solely licensed as a servicer, but yet they're going out and foreclosing left and right and just stealing these homes with no authority from any lender. And this is where it needs to stop. I think I spoke about this before.
Yeah.
And then these illegal debt collectors are the ones who called and hired Safeguard or a preservation company to begin with. Oh, well, I represent such and such lender, they call them, you know, and I order you to start inspecting this property. Now, when they place these orders, they can place an order to actually enter the property or just place an order to just case the property, just kind of drive by and check the outside. So Safeguard can do all of the above, and then if you call the police will say, well, that's just a civil matter. It's because you're being foreclosed on. And the lender could actually enter your house. They think it's all okay.
Wow. Eric, I just got one more question for you, then I want to talk about something else real quick. Now the bank cannot continue the foreclosure process if you reinstate your mortgage before the sheriff's sale. And in order to reinstate, you will need to pay the amount that you are behind plus the fees and the costs and things like that. So explain to people how they cannot continue the foreclosure process if you reinstate your mortgage before the sheriff's sale.
Okay, starting with the law and how it works, the federal law and the state law, okay, the way it's supposed to work, of course, no judges listen to this, but your loan has to reach a point of acceleration. That means, like in the old days, they used to call it, the bank is calling the loan.
Right.